はい。では、定刻となりましたので、始めたいと思います。私は、弁護士の高取と言います。今日、共同主催をしている、英国仲裁人協会、チャータード・インスティテュート・オブ・アービトレーターズの共同代表、それから講演をしている、日本仲裁人協会の常務理事をしております。本日は、法務省さんと英国仲裁人協会日本支部共同主催と、いうことでオンラインセミナーをいたします。タイトルとしては、知的財産紛争をめぐる国際仲裁と訴訟の戦略的活用と、法務省掲載のビデオ動画を参照してということで、国際仲裁調停の研修動画が法務省のホームページ、YouTube にもアップされましたので、それを記念して、行いたいと思います。一応今日はその研修動画を見られた方、あるいは見る予定の方、含めて、日本語、英語、両方、理解されるということで、行っておりますので、同時通訳等はつきませんが、ご了承いただければと思います。はい。ではですね、あと、今日は、順番としまして、主催者からの挨拶の後、私のケーススタディといいますか、今日の趣旨説明、それからアレックス・チャチキス弁護士のプレゼンテーション、で、最後にパネルディスカッションを行いますけれども、その間ですね、ご質問がある場合には、Q&A ボックスというところで入れていただければ、適宜こちらの方でパネルディスカッションの際に、ピックアップして、お答えをするという方式で、参りたいと思います。では、早速、まず今日の、共同主催者であります、法務省大臣官房国際課の神吉浩二さんから、浩二様からご挨拶いただきたいと思います。神吉様は、ですね、まさにこの国際仲裁、活性化ということで、法務省がリードとって、行っている中心人物でいらっしゃいまして、今回の研修動画の策定企画、それからアップに関しても多大な尽力をされていて、引き続き我々と協力してくださっている方です。では、神木様、ご挨拶よろしくお願いします。
はい。皆様、おはようございます。ただいまご紹介に預かりました法務省大臣官房国際課の神吉浩二です。本セミナーの開催に際しまして、主催者であります法務省を代表いたしまして、一言ご挨拶申し上げたいと思います。まず、本セミナーを法務省とともに主催していただきました、英国仲裁人協会 CIArb 日本支部の皆様、また、本セミナーを講演していただきました日本仲裁人協会日本国際紛争解決センターの皆様に対しまして、深い敬意を表したいと思います。ありがとうございます。国際仲裁はご案内の通り、クロスボーダー取引におきます紛争を解決する手続きのグローバルスタンダードとなっていますが、日本における、我が国における利用は未だ低調のままです。日本企業の国際取引をさらに活発化させ、また、日本企業の海外進出を後押しするためには、法的紛争が生じた場合に、その紛争を我が国において安心かつ確実に解決することができる仕組みを整えることが重要となります。法務省では国際仲裁の活性化に向けて、関係省庁、関係機関の皆様と連携して、国内外の企業に対する広報、意識啓発、仲裁人、仲裁代理人等の人材育成、そして仲裁専用施設の整備等の各施策を積極的に推進しているところとなります。また、仲裁関連法制の整備を進めておりまして、昨年5月に外弁法を改正するとともに、現在、仲裁法改正の作業も鋭意進めております。このように法務省では、国際仲裁の活性化に向けて、インフラ整備、そして法制度の整備を車の両輪として全力で進めております。本日のセミナーでは、本年9月に法務省の YouTube チャンネルにアップいたしました解説付きの模擬仲裁動画を題材といたしまして、主に知的財産紛争をめぐる国際仲裁と訴訟の戦略的活用につきまして、 本模擬仲裁動画に代理人としてご登壇いただきましたAlex Chachkes弁護士をお招きして、解説者であります高取弁護士との間でディスカッションを行う予定と聞いております。本日のセミナーは、主に国際仲裁の関心のある若手の弁護士、そして企業法務担当者向けのものであります。参加者の皆様におかれましては、本模擬仲裁動画、および本日のセミナーによりまして、国際仲裁、調停の理解をさらに高めていただき、我が国における国際仲裁の活性化にご貢献いただきたいと考えております。結びに、本日のセミナーの成功、そして我が国における国際仲裁の活性化が進み、日本企業による海外進出の後押しとなり、我が国にとどまらず、アジア、ひいては世界経済のさらなる発展につながることを記念いたしまして、私の挨拶とさせていただきます。ありがとうございます。
歓喜様ありがとうございます。今回もですね、法務省様にも主催いただいて本当に感謝申し上げます。で、今日のセミナー、これオンラインで行っておりまして、実は私の事務所のアソシエイターである佐々木弁護士が全面的に技術的なサポートをしてくれまして、今、法務省の方でページアップされている研修動画についても、佐々木弁護士が編集してくれました。これを感謝申し上げます。では、続きまして、英国仲裁人協会日本支部、Chartered Institute of Arbitrators のジャパンチャプターのチェアである、ダグラス・フリーマン弁護士から挨拶をいただきたいと思います。で、彼は、ご承知の方も多いと、有名な弁護士、アービトレーターでありまして、まさに、クロスボーダーのですね、紛争解決の中心、人物であり、かつ、日本の司法試験も、外国人で、ネイティブで初めて受かったという、リーダーでございます。では、ダグラス・フリーマン弁護士、よろしくお願いします。
Thank you, Yoshi, for the introduction. Good morning, everyone. I serve as the chair of CIArb Japan chapter, and it is our honor to sponsor today's event in conjunction with the Ministry of Justice as part of Japan's ongoing project to broaden the use of arbitration in various fields of law. 共同主催者として今日はご挨拶させていただきます。私は今回、解説者でもあります高取弁護士とともに CIArb 英国仲裁人協会の日本支部の代表を務めておりますダグラス・K. フリーマンであります。CIArb という組織は世界149カ国に17,000人のメンバーを有する、ほぼ唯一のですね、その国際仲裁 ADR 教育を目的とした非営利のグローバルな団体です。で仲裁人のためのそのメンバーのですね、その認証コースや、次回の、各国のですね、仲裁人をつなげるイベントなどを実施しております。今回このような形で多くの方に国際仲裁の有用性を知っていただける機会を持てることはとても嬉しく感じております。今回は法務省様の方から、国際仲裁や調停の利用を促進する広い活動の一環として、国際模擬仲裁の、研修動画を公開されまして利用可能となったことを記念して、これをさらに一歩進めてこの中でケーススタディとして、取り上げられた、知的財産紛争を題材にどのような場合に、知財紛争を仲裁によって解決することが有益であるかなどについて、この研究動画の作成に、直接携わられた高取弁護士と、知的財産権の専門弁護士のアレックス・チャッキス弁護士をお招きして、アレックス弁護士によるプレゼンテーションと、高取弁護士とのディスカッションを行います。高取先生は、CIArb の共同代表を務めて、おりまして、国際仲裁の日本全国に、広めていくアンバサダーのような方でありまして、また国際仲裁人としてもご活躍されて、チェンバーズ市などから高い評価を得られております。アレックス弁護士は、米国で25年以上、知的財産紛争の経験を持つ著名な専門家弁護士で、この分野では多くの賞も受賞されています。それではどうぞよろしくお願いいたします。
フリーマン先生、ありがとうございました。 CIArb とですね、それから、またその法務省、JIDRC、それから JA 協力して、また研修プログラムを、弁護士のみならず、いろんな方に提供していくというプロジェクトも、進行中ですので、ぜひ、よろしくお願いします。また、今お話ありましたように、先ほど、歓喜様からもご指摘あったように、日本の国際仲裁活性化ということで、先日も日経新聞でちょっと停滞していると書かれてしまいまして、私も人材育成ということを整えれば、大いに未来は明るいというつもりでコメントしたんですが、若干、ネガティブな形で引用されてしまいましたので、さらに、こういう機会通じてですね、研修、啓発、努めていきたいというふうに思います。では、早速、今回の研修動画の、ご覧になった方が多いと思いますので、上塗りはしませんが、ポイントのイシュー、特に知的財産を含めての部分について、少し、復習をした上でですね、この後、アレックスの方につなげたいんですが、ちょっと私の方で、画面を私のスライドに共有させていただきます。はい。知的財産紛争をめぐる国際仲裁と訴訟の戦略的活用ということで、今回のビデオはですね、ご覧になった方多いと思うんですが、私はジャパンプラクティスのヘッドをしてましたオリックという、グローバルファーム、1200人ぐらい弁護士いたんですが、そこの、仲裁人を務める者、それから調停人を務める者、実際に活躍している人、それからアレックス・チャチキスのように、ニューヨークで知的財産訴訟、アービトレーション、バリバリやってるのを招集しまして、模擬仲裁を調停とともに、平成30年ですかね、行いまして、で、その動画をもとに、解説したものをアップしているんですが、その知的財産の論点がですね、非常にやはり今後の国際仲裁調停の活用という意味では、重要なコアの一つですので、そこにフォーカスを当てて、今回、行いたいと思います。で、動画の方は、ご承知の通り、準備手続き、それから調停の手続き、それからアレックス・チャチキス含めて、調停人、それから仲裁に務めた、弁護士とパネルディスカッションもしてますので、それもまたまだご覧になってない方はご覧いただきたいんですが、その足がかりにでも、していただければと思います。このケーススタディについて復習することはしませんが、国境をまたがって、日本の企業と、それから米国の企業が、主にその知的財産、テクノロジーの、ライセンスをめぐってですね、そのライセンス契約違反という契約紛争なのか、それとも、そもそも、オートソフトが持っている特許権の侵害という特許権侵害訴訟として、その特許権が登録されている米国での、訴訟の方が適合するのかという、その手続き的にそもそも、知的財産訴訟で行うのか、あるいはライセンス契約上に、規定されている仲裁条項ですね。この場合ですと ICC 仲裁条項、それから仲裁地位は日本、東京ということで定められているんですが、そちらでやるべきなのかということで、まずはそのオートソフトが米国、イーストテキサスという、知的財産の訴訟で、有名なところ、ある意味、原告を勝たせやすいというところで、訴訟地になりやすいところで、提起された紛争について、日本のセルモーター側が、いやいや、これは、仲裁条項があるんだから、暴走抗弁というんですけれども、仲裁で行うべきであって、訴訟については却下すべきと。あるいは停止すべきということで、まず停止させたというところから始まっています。ですから、特徴として、国境がまたがっているということ、それから、訴訟、裁判になるのか、あるいは仲裁で解決すべきなのかという、そこでまず、争いが起きる。仲裁庭側から見ると、その仲裁庭に裁く権限があるのかないのかというところが、まさに問題になりまして、これはジュリスディクションというんですが、日本語で言うと管轄、あるいは、仲裁庭の裁く権限とでも言うんですかね。それがあるのかないのかという争いが行われて 準備手続き会でそこが、議論されて、最終的には、仲裁庭に裁く権限がある。つまり、管轄がある。つまり、仲裁条項が有効であり、この紛争も裁くことができるという、結論を出して、行いました。で、こういう管轄の争いというのは非常に、実際私が行っている仲裁の案件でも、多く争われるという印象を持っています。やはり、当事者が合意をして、その裁く権限、プロセスを進めるというのが仲裁の特徴ですから、そもそも、仲裁庭に向かってですね、あなた方には裁く権限がないと。あなたたちに裁かれるんではなくて、裁判で行われるべきですという、ある意味、仲裁庭からするとその失礼なですね、主張が、なされるわけですけども、そこが失礼にならないように、手続き的には、こういう条項は、あなたたちのオーソリティ、パワーを基づけるものではありませんよ、ということを主張し、その場合には、もしパワーがなければ、訴訟で行われるべきでありましょうと。で、本件の場合ですと、特許権というですね、知的財産。で、ご承知の通り、知的財産というのは、目に見えるものではない。要するに車を持っている。ごめんなさい。要するに、財産として、車という物体があるとかですね、本という物体があるとかですね、そういうものではなくて、あくまでもその法制度によって生み出された、概念的な財産ですから、これが、米国法に基づいて、特許権ということで存在して、それのその侵害かどうかということに着眼すると、これは米国での訴訟になるのかと。ただ、しかしながらですね、本件の場合はライセンス契約という、そのテクノロジーのライセンサーとライセンシーがいて、その使用対応、あるいは権限を超えて、使っているのではないかという、紛争と見ると、ライセンス契約違反ということで、まさにこの ICC 仲裁条項が入ってくるのではないかということで、このように特許権侵害訴訟で行うべきなのか、ライセンス契約紛争という形で、仲裁で行うべきかということも、これもよく実務で争われます。ですからこのあたりもまた、この後、アレックス・チャチキスの方から、近況といいますか、その論点、ポイントの説明があると思います。一応このレジュメに関しては日本語と英語両方でですね、アップしまして、できれば、後ほどオーディエンスの方に、ご配布できるようにしたいですけども、ケーススタディそのものについては、法務省の方のページからもダウンロードできるようになっています。で、事案の概要としてライセンス契約上、セルモーターはライセンスとプロダクトについて、オートソフトの特許技術を利用することが許されていると。この点、ライセンスとプロダクトは Any Motor Vehicle というふうにですね、Any Motor Vehicle という、定義のところが問題になるっていうのが、実態として、動画の中では紛争の対象になっています。で、電気自動車がライセンス契約の対象外であれば、特許権侵害が問題となるし、対象内であれば、ロイヤリティの算定が問題となるというふうに、まさに特許権侵害訴訟なのか、その契約条項、契約の合意の範囲内なのか外なのか、合意に反するのかということが問題となるという事案で、ロイヤリティの算定についても、販売台数に関わらず年間、1000万ドルの固定なのか、販売台数に応じた支払い、1台あたりの算定でいくのかというその契約の解釈についても、内容については問題となるという事案です。これもご覧になった方はご承知だと思いますし、まだの方はぜひご覧いただければというふうに、思います。で、契約の準拠法は、カリフォルニア準守法ということで、仲裁において問題になる、契約、ごめんなさい、その準拠法というのはですね、こういうふうに契約そのものの準拠法、それから仲裁手続きが行われる手続きの準拠法、それから本件で問題となったように、その仲裁合意の準拠法というのが問題になる。大きく3つあるというところを押さえておいていただきたいです。ここはごっちゃに定めているような、定めているのか定めていないのかわからないような契約というのもすごく多いんですが、ここが争いであることが非常に多いです。Any disputes arising out of the agreement shall be resolved in the arbitration under the rules of arbitration of the International Chambers of Commerce, ICC ですね。で、3人の仲裁人で裁かれるという合意になっています。で、やはり仲裁の根本というのは私的自治、当事者の合意によって当事者が合意をして、 その選任したアービトレーターが裁くわけですから、その合意がないとなると、ある意味すべて吹っ飛ぶということになるわけですね。で、仲裁人が、規則によって選ばれる場合も、そもそもその規則を合意したのは当事者ですから、そこはやはり当事者の合意が基礎にあるということになります。で、仲裁地は日本国東京ということで、定まってまして、本件契約から生ずるいかなる紛争もその仲裁によって解決ということになっていて、アライジングアウトオブという文言だけでですね、in connection with 関連してという文言がないんで、狭く返すべきかどうかという、まさにその手続き的なことが争われているのが、この動画でして、その中でも、今日プレゼンテーションをしてくれる、アレックス・チャチキスは、オートソフト側の代理人弁護士として、バンバンその辺をこうついてですね、議論をしてます。そのあたり、あまり、リハーサルをせずですね、生で実際に争っていただきましたので、かなり迫力がある動画になってるんじゃないかというふうに、思います。英語の解説もつけておきました。で、仲裁準備会としては、文書提出とですね、それから、被得特権、プリビレッジが、大きく2つ、争われている。問題になっているという形になっています。動画の方はですね。これは、ディスカバリーというその文書提出ですけども、昨今の傾向としては、IBA ガイドラインに基づいて、限定的に行われるという、ことが、通常のプラクティスとしては多い。で、これをガイドラインとして利用するというのが、文書提出ですね。で、その、ごめんなさい。この文書提出とそれから被得特権というのが一つの論点で、先ほど申し上げた管轄というのが大きい一つの論点で、その二つの論点について、仲裁準備会では、争いになっているというふうになっています。で、もう一つの論点であるこの、被得特権というのは文書提出に関して、どこまで開示すべきかと。で、弁護士のリーガルアドバイスですね。これに基づくものは、プロテクションがかかるという議論に対して、オートソフト側は、アレックス・チャチキスのように、その、弁護士資格があるものがですね、その、行われた、コミュニケーションが主なんですが、日本側は、法務部に、弁護士資格がある方が、いない場合も多いと。で、そのコミュニケーションはどうなるのかとかですね、あと、法務部の方たち、あるいはインハウスの、資格を持たない方の、コミュニケーションはどうなるのか、あるいは資格を持っていても、インハウスのコミュニケーションは、ビジネス的なコミュニケーションであるという推定が働いて、実はそこを覆さないと、リーガルアドバイスとして、プリベージでかからないというような考え方を取る仲裁系も多いので、そういうことが論点になっているということに、なります。そして、動画ではですね、パネルディスカッションの中で、アーブメッドアーブの活用と比較とかですね、それから、今日またさらに、少し突っ込んだ議論を、アレックス・チャチキスとしたいんですが、知的財産の紛争解決における国際 ADR 仲裁、調停の効用、から知的財産紛争解決のための ADR において、選任すべき仲裁人、調停人の資質は何なのか。この後また、プレゼンでも少し触れてもらう予定になってます。から、プラクティスエリアの要素はどうなのか。それから知的財産特有の経験や能力を優先すべきなのか、あるいは、ライセンス契約といっても、その特許権のテクノロジーに詳しいというよりは、ライセンス契約という商事契約ですね。その紛争解決に、経験や能力を優先する、持つ人を、やはり仲裁人として選ぶべきなのか、というようなことも、現実の場面では非常に重要な問題になります。つまり、裁判では、裁かれる裁判官というのは選べないんですね。ですけど、仲裁では、当事者の合意で、まさに誰を選ぶかということが、生命線になってきます。よくうちの企業は仲裁を行ったんだけども、とんでもない目にあったんで、もう二度と仲裁なんか使うかということを、憤慨しておっしゃっている方もすごく多い。多いというか、そういう、法務部とかも多いんですが、その話よく聞いていくと、どうもその仲裁人の選び方のところで失敗しているというようなところもあります。また、そもそも仲裁条項の作り込みのところで失敗しているというところもあるので、これは仲裁というシステムが悪いんじゃなくて、ある意味、ちょっとその自己反省も含めてですね、ここを改善すればよかったんじゃないか。契約条項の作り込みを改善すればよかったんじゃないか。あるいは、ここが、履行に、不能、債務不履行になりそうだという、その、肝のポイントがあれば、そこを結局もし争いになった場合に、どこで仲裁をして、具体的に誰を選ぶことができるのか。ここの仲裁地であれば、 こういう仲裁人を選ぶことができて、こういう分野に長けている人がリソースとしています。まあ、本当はそこまで考えた上でですね、作り込みをしておくということが、重要なんですが、どうもそのあたりが、欠けているという部分はあります。まあ、そのあたりも、特に知的財産については、重要な部分になってきますので、後ほど、プレゼンテーション、それから、ディスカッションをしたいと思います。知的財産紛争解決用の仲裁条項の作成法やドラフトのポイント、インハウスの役割なども、動画の方でもディスカッションをしています。それから、接吻、これはスタンダードエッセンシャルパテント、標準必須特許と言いまして、まあ、例えば、5G ですとかですね、要は、自動運転のその AI の技術ですとか、非常に高度な技術だけれども、それがないと世の中が立ち行かないというか、世界的にこれを普遍的な技術として、まあ、広めることがその人類共通の利益であるというようなものに関しては、スタンダードであり、エッセンシャルであるという、その特許、についてはですね、いわばその、アンフェアに独り占めさせると、これはまた独禁法に関係するような論点も出てくるんですけども、そういう不当なことが起きないように、フランドと言いまして、フェアでリーズナブルでノンディスクラミナトリー、つまり非差別的なものは交渉はしないというような要件が定められているというような、そういう紛争がですね、ヨーロッパでも起こり、アメリカでも起こり、という、そのアジアでも起こりという、そのいつまで経っても解決しないというようなことも実際起きてまして、これは国境を越えたやはり仲裁で、ひとまとめに解決をする。まあ、このプロセスについて合意をするということは、延々と争い続けるその当事者にとって両方とも消耗戦になりますから、これはどっかで包括的に行うということは共通の利益になりますし、あるいは調停ですね。で、これも国際調停、私もやっておりますけれども、もっとですね、ビジネス的に、過去に起きているその紛争について解決するだけではなくて、将来を見据えた解決を共通の目的で行っていきましょうと。ですから、例えば、接吻、あるいはその知的財産に関しては、将来のこの知的財産の技術については、これをこういうふうにまた新たにライセンスをして、お互いウィンウィンでビジネスをやっていきましょうというような調停の条項、調停の合意というのもあり得るわけで、非常に、知的財産、高度技術、その接吻を含むような紛争に関しては、クロスボーダーで、使い勝手が良いのではないか。で、実際に、今日プレゼンしてもらう、アレックス・チャチキスのようなその IP リティゲーターのみならず、アンタイトラスト、つまり独禁法のスペシャリストも、この分野においては、アービトレーションや調停を行っているという部分がありますので、そのあたりの、ディスカッションも行っています。で、まあ、そういう考慮をした上で、どういう戦略を取るかというようなパネルを行っているという状況になります。ですから、今日、そういう部分含めてですね、特に知的財産のに関して、アレックス・チャチキスの方から、プレゼンをしてもらいたいと思いますので、それで今、共有を解除しましたので。では、ここでですね、アレックス・チャチキス弁護士を紹介したいと思います。彼は、私が昨年までおりましたオリックの元同僚で、彼もその後、辞めてしまったんですけど、自分でIP、知的財産の専門の事務所を開設されて、チャチキス PLLC というところのパートナーをしています。で、動画では、オートソフト側の代理人として、非常に鋭い議論をしているということで、まあ、直接そういう人物の話を聞いた上でですね、後ほどまた質疑応答を含めてパネルディスカッションをしたいというふうに思います。Okay, so Alex, so could you please start? Thank you very much for your waiting.
Great, and you can see my presentation?
Yes, sure.
Okay, great.
Let's go ahead.
Good morning, everybody. My name is Alex Chachkes. I'm a patent litigator. I've been working on patent cases for about 25 years. Most recently, I was a partner with Takatori Sensei in the law firm of Orrick Harrington, and earlier this year started my own law firm, and this is the first year of our existence. So what I'm going to talk about today is really the difference between arbitrating and litigating a patent dispute, and why one might be better than the other, how one might arrange to arbitrate patent disputes rather than litigate them, and what are the pluses and minuses. So this presentation has 5 sections. First, we'll talk about what's good and what's bad about patent litigation in the federal courts in America. 2 is we'll discuss what's good and what's bad about arbitration and as opposed to litigation. 3, we'll talk about whether or not, who decides this, whether to arbitrate and whether to litigate. 4, when must patent disputes be arbitrated, and finally, how to draft arbitration provisions in contracts. So for this first section, excuse me, so what is good about patent litigation? I think from many people's perspective, nothing is good about patent litigation, especially in America. It's expensive, it can be slow, it's time consuming, and distracting. It's distracting to management, it's distracting to the employees who have to be involved in patent litigation. But if you're going to have a patent litigation, it has certain advantages over arbitration. For example, one is that you have more robust discovery. I know in Japan, disputes, there's a limited amount of discovery, meaning the ability to ask questions of the other side, the ability to demand documents from the other side. If that's an important aspect of what you want in a dispute, then litigation is better. Another thing that is good about litigation in the US courts is that almost all the courts in America have very careful, well thought out, methodical rules for how to prepare a patent litigation for trial. And this, a lot of patent lawyers, including myself, think this is important. So for example, you want to have claim construction, that is the understanding of what the terms of the patent mean. You want that to exist. You want that to happen early, because if a patent is like, a patent defines what you own as in terms of intellectual property. If you want that patent interpreted early in the case, because you want to know what you're arguing about. If you don't have the patent interpreted until late in the case case can be very messy, as both sides have different understandings of what the patent means. And so the rules in the federal courts are very accommodating to that kind of procedure to define the patents very early on. Patent litigation tends to be better for the party with a better story or a narrative. So in US courts, often that means the patentee or the owner of the patent, because these cases go before juries. Juries love to hear the story of an inventor. They love to hear the story of creating intellectual property, and they tend to favor, if your story is good, they tend to favor patent owners for that reason. In litigation, of course, arbitration, you don't have a jury, so that's different. Litigation tends to be better for the local party, the domestic party. So if you're a Japanese company against an American company in Texas for a patent litigation, juries tend to favor the American company a little bit, and depending on where you are. So for example, in the Northern District of California, you don't see much favoritism towards domestic companies. It's a very international kind of place. People are well educated. People understand, the nuances of international, multinational companies. Jury case in Texas, maybe that's not the case, depending where you are. And if you're a Japanese company, you may find that the plaintiff is doing and saying things that kind of emphasize that they're local, that they are American. And that doesn't happen in arbitration, or you really don't get away with that in arbitration. And then finally, litigation in the courts, it's expensive. It can take a long time. There's a lot of discovery, but if there's something good about that, it is that you end up potentially with a better result. With a better result because you not only do you have a more thorough investigation of the facts through discovery, but you also have the appeal process. If something goes wrong in the trial, the appellate court in the US, the appellate court for patent cases is the Federal Circuit. They're a very good court. They're very careful and are quite good at finding error and correcting it. And this is important in patent cases because they're very technical. And technical cases, it's easy to make mistakes because not everybody's an engineer. The judges aren't engineers. The jury's not an engineer. And in arbitration, the arbitrators usually are not engineers. So that extra layer of protection on appeal, some people like. So what's good about arbitration? There's a lot that's good about arbitration. I think the last point on this slide is the biggest one, that it's less expensive, less discovery. It is no depositions, so it's less distracting to your employees, less burdensome collecting documents, less of your confidential information is being given to the other side. And that's one great big reason why people love arbitration, to keep those costs down, to avoid discovery. Going to the top of the list, no local favoritism. Arbitrators are not there, especially in international arbitration and patent arbitration. There's just no distinguishing between, I don't care if you're a Japanese company or a German company or an American company, there's no favoritism. Also, it's potentially a quicker resolution. Arbitration tends to be a bit more streamlined and you can get a quicker resolution. Another good thing about arbitration is confidentiality. I've been involved in arbitrations where the judgment was $1 billion, for example, and that doesn't get into the press. So if you lose, it's not embarrassing. You resolve it with the arbitrators and you move on with your corporate life. And then finally, there's maybe greater procedural flexibility, especially if the parties agree on the procedures that they will abide by if they go into arbitration. You can pick the location, for example. So in federal court litigation, you're kind of stuck where the plaintiff picked to sue you. So if they sue you in Texas, you might end up litigating in Texas, even though you're a Japanese company. But if you're a Japanese company in a contract with a German company and neither of you wants to be in the other jurisdiction's courts, the Japanese company doesn't want to be in German courts, the German company doesn't want to be in Japanese courts, you can pick a neutral place like Hong Kong. And you can pick neutral arbitrators who are neither Japanese nor German, or some mix of both. And also, there are international centers for arbitration, like in Japan, Tokyo, Osaka, or Singapore, or other places around the world, which are, welcome centers for arbitration. You can select your procedural law. You can select the substantive law. All those things that you regret in litigation because you don't have a choice. You do have a choice in arbitration if you make the decision early on. And also you can pick the language. So who decides whether to litigate or arbitrate? Well, obviously all arbitrations are the results of contracts. The contract between you and the other side has to say, we're going to arbitrate our disputes. Then the question is, what kind of language do you use in the arbitration clause to determine what exactly is arbitrated and what exactly is not arbitrated? So in the US, the rule is that the questions of whether you arbitrate or not are for a court, unless there's clear evidence that the parties wanted an arbitrator to decide whether to arbitrate or not. So usually, for example, if you if the arbitrators have been given the right to determine whether the dispute is subject to arbitration, then if that is very clear in the contract, then the courts, at least in the US, will respect that. So if you are in your arbitration contract, in the contract, have an arbitration clause that clearly sets out that the arbitrator decides what is arbitrable, what is not arbitrable, then that's when the arbitrator decides. And in fact, you don't need to necessarily set out the precise, that you don't have to say in those words in the contract, okay, the arbitrator will decide what gets arbitrated. You can simply incorporate by reference the rules of an arbitration organization, like the American Arbitration Association, or and one of the many other arbitration associations. Okay, so when must patent disputes be arbitrated? All arbitration is a creature of contract. So inevitably, if you're going to have a patent issue in an arbitration, it's usually because, like in Takatori Sensei's presentation previously, it's a license to technology, and that's a contract. And then what happens usually is one side says the license ended, or the other side went beyond the license, and therefore you are using unlicensed technology, which is patent infringement. So in arbitration, these contract issues and patent issues tend to be intertwined. The contract issue comes first. Are you licensed? If not, then there's a patent issue. So the question is, what gets arbitrated? Well, if your arbitration clause uses this language you see on the screen, it says all disputes or any controversy, so something broad like any or all, arising out of or relating to an agreement. So if your arbitration provision says it's arbitrable, all disputes relating in connection with this agreement are arbitrable, that's when the patent dispute gets swept into arbitration as well. It really, for the patent dispute to be not arbitrable, you have to have a more narrow arbitration clause, and I'll show you some examples in a moment. As you can see, there's many cases deciding when patent disputes are arbitrable. Courts tend to look carefully at the arbitration provision, but again, if you say anything that relates to the contract or arises out of the contract is subject to arbitration, that's when the patent disputes goes to arbitration. Even though the contract really is, it's a patent license, and you don't expressly say that patents are subject to arbitration. If your arbitration clause is broad, the patent dispute will get arbitrated. Here are some clauses where courts have decided that all the patent disputes are subject to arbitration. In many countries, for example, many countries, patent validity is a very separate and different question from infringement. And patent validity is often decided by a country's patent office and not by the court, not by the litigants in a court dispute. And so in the US, at the very least, long ago, people would argue, well, I know I agreed to arbitrate this license and anything relating to this license, but patent validity is different. That's a separate matter. It's not really for arbitration. And the courts over time have rejected that understanding. So even validity will get arbitrated if you have a broad clause in your patent license agreement. In your license agreement, that is. So the question is then, when do arbitration agreements not include patent issues? Well, there's got to be an express carve-out, and the carve-out can come in many forms. So for example, in the first bullet, I have a case from an appellate court from the Federal Circuit from 2016. And if the contract expressly carves out a subject matter, here, if it expressly carves out intellectual property rights or patent rights, then even if the arbitration agreement is otherwise broad, courts will not send the patent issue to arbitration. So in the Veronata case, there was a very clear express provision that said the arbitration agreements will not apply to disputes relating to scope, infringement, validity, or enforceability of intellectual property rights. It was very clear, and the court said, okay, arbitration, the contract issues go to arbitration, the patent issues stay in federal court. There's another carve out in this Radware case from 2013. Again, this is a subject matter carve out. If the arbitration provision only expressly mentions one patent, then even if the other patents are related, they won't go to arbitration. So, for example, counterclaims will not go to arbitration even if they're related. Or if there are two patents in the same family and the arbitration agreement only refers to one patent, only one patent will go to arbitration. And that can lead to some very difficult situations if there's only one patent mentioned in the arbitration clause, then you could find yourself both in arbitration and simultaneously in litigation at the same time, which is incredibly expensive and very burdensome on both parties. So, but that's one kind of carve out. Another carve out we see in that last bullet, the Let's Go Arrow case from 2015, is a temporal carve out. So a carve out based on time. So any disputes after a particular time are not subject to arbitration. Any disputes before a particular time are subject to arbitration. And in the Let's Go Arrow case, there was a settlement agreement, and there was a termination of the license agreement and a settlement agreement, and the arbitration clause did not apply to conduct after the settlement. And so even if it's related to the original arbitration clause, if you carve out based on time, then something that happens after that carve out will not go to arbitration. Okay, and finally, we'll talk about considerations in drafting a patent arbitration clause. And this is very important because many parties, it's easy to agree to an arbitration clause, but you really want to think carefully about the words of the arbitration clause, because if you ever do arbitrate, you want to make that arbitration the kind of arbitration that makes it a good alternative to litigation. So a typical arbitration clause will occur. So when two companies from two different countries enter into a contract, often they'll have an arbitration clause. So I recently had a case where one company was French, another company was German. The French company doesn't want to be in German courts. The German company does not want to be in French courts. So they picked so they had an arbitration clause, and the seat of the arbitration was in the United States. So both of them could avoid, so no one was in their home country. And they picked American law as the law that would govern the agreement. That way there was no favoring the French party with French law. There was no favoring the German party with German law. But neither party had looked at American law closely to see what kind of implications it had for their agreement. And had they thought about it previously, maybe they wouldn't have picked American law as the law for the arbitration. And that's just one example. So let me go through a few examples of all the different things you can put in an arbitration clause to make sure if there is an arbitration that it's straightforward, it's streamlined, it's inexpensive, and it's a good alternative to litigation. So the first is scope. What do you want to arbitrate? As I mentioned before, a broad arbitration clause sweeps everything into arbitration. If you say all disputes arising out of or relating to this agreement, every dispute you have that has any way related to the contract gets swept into arbitration. And maybe that's what you want. But if that's not what you want, think carefully and draft the arbitration provision accordingly. So for example, you may want to include counterclaims that unlicensed patents that the other side has. And that way, if there's counterclaims in patent infringement, they go into arbitration too, and you can take advantage of the efficiencies of having every dispute of both parties before one arbitration tribunal. What about if, so for example, in the hypothetical that Takatori Sensei had in the previous presentation, there was a subsidiary. Well, what if there's a license to a company and the technology is going to be used by a subsidiary? Well, is the subsidiary subject to the arbitration agreement? Well, what happens if the subsidiary didn't sign the contract? Can you force the subsidiary into the arbitration if they resist? And that involves complicated questions of the corporate relationship between the parent and the subsidiary. Can the parent sign something and oblige the subsidiary to show up to an arbitration? And if this is a potential problem, you may want to make it very clear that the subsidiary is agreeing to arbitration, and that will avoid an expensive dispute when the subsidiary decides, well, I'm not going to join the arbitration, and then you have to litigate that question, and that's just more expense, more time. So that's something to think about. What parties do you want in the arbitration? Who needs to sign the agreement? Who needs to be mentioned in the arbitration clause? And then finally, consider how again how broad the arbitration clause sweeps, because the last thing you want is to have arbitration and litigation at the same time. One thing that parties often don't think hard enough about when they agree to arbitration, especially arbitration that could have patent issues, is do you want to make sure the arbitration is equipped to handle a patent dispute? So some arbitration bodies are better than other arbitration bodies for patent disputes. Some arbitration bodies have patent-specific rules that make it easier to have to resolve a patent dispute. Some don't. And so you have to look at which arbitration body, which arbitration rules you're agreeing to, for example, AAA or WIPO, and what kind of patent rules do they have? WIPO, for example, has very robust patent rules that include robust discovery. Then, AAA has good patent rules that have the kind of procedures that make litigating and patent disputes easier. For example, early claim construction, which makes the claim, the case much clearer. You may consider putting the procedures into the contract yourself, so that even if the arbitration body doesn't have their own procedures, you set them out in the contract in the arbitration clause. And I just mention this last slide. I've been involved in arbitrations where there were no patent-specific rules, and it really was kind of a mess. The arbitrators didn't have any familiarity with patent rules. They didn't have a familiarity with patents. There were no specific provisions in the arbitration clause for involving somebody with patent experience in the tribunal, or with somebody with technical experience. And so when you pick the arbitrators, usually you pick them with the contract issues in mind, because the contract issues always come first. Am I licensed? is a question that comes before, do I infringe a patent if I'm not licensed? And so usually the parties pick their arbitrators based on their contract experience and not based on their ability to understand a patent case. So that can lead to a lot of problems down the road. Interim measures is another thing to think about. Interim measures means, what if you're in the kind of situation where if there's a problem, you need relief right away? In the US, that would be like a preliminary injunction or a temporary restraining order, some sort of order that if somebody is infringing your IP rights, you can get them to stop right away. And that can be important in a market where there's only 2 or 3 or 4 players. If someone's infringing your patent, you want them to stop right away, maybe even before the end of the lawsuit or the end of the arbitration, which can take, over a year. And so you have to consider, do the rules of the arbitral body that I've picked have interim measures that are effective? If a party resists interim measures, what happens? Let's say I go to an arbitral body, I say, I want the other side to stop using my IP right away, and the arbitration body agrees and issues an order. What good is that order if a court will not enforce it? So you've got to make sure that there is a mechanism for the courts to enforce the order, the interim measure order of the arbitrable body. And that is easier when the contract says that interim measures are something contemplated, and those interim measures will be enforced by some court in the jurisdiction where the party using the IP exists. Sometimes, for example, you want to name a court. So you could say, well, this will be enforceable in the Southern District of New York, for example. And the reason you might want to do that is because it prevents a party from objecting to jurisdiction in that court and saying, well, no, I don't belong in the Southern District of New York. You can't enforce the order here. I object to jurisdiction. Well, that objection becomes much more difficult if there's an express provision in the contract. And then another thing that can be very important is putting into your contract provisions about the selection of arbitrators. Again, in most arbitration cases, people pick the arbitrators, whether it's one arbitrator or 3, 2 wing arbitrators and an intermediate arbitrator, pick based on their knowledge of contract law or their reputation as lawyers with sort of a general knowledge of the law. What about if the case is going to have a patent issue? It's probably you can't have a patent, you can't have an arbitration clause that says, well, the arbitrators must have experience in both contract and in patent, because you're just going to limit the pool of arbitrators that are available to you. But you have to think, well, what's going to happen if we're going to have a patent dispute? Maybe we have 2 phases. We have a phase 1, which is the contract phase with one set of arbitrators, and a phase 2 with another set of arbitrators, or a single arbitrator that has experience with patent law. Or you could have the normal arbitrators, 1 arbitrator or 3 arbitrators, however many you agree to, however many are appropriate under the rules that you agree to, and then have a consultant, somebody who is got experience with patent law, or at the very least with technology, the technology in that's addressed in the contract. So it could be very useful if you've got an arbitrator who has no technical background, if the parties pick a neutral engineer who can understand the technical arguments you make, and then talk to the arbitrator and allow the arbitrator to understand the underlying technology, which is so important for a patent dispute. That's another option that you could choose. which can be less expensive than, say, having 2 tiers of arbitrators, one for contract issues, one for patent issues. And then for those arbitrators, for example, if you want a technical arbitrator or you want a patent-specific arbitrator, you can lay out their qualifications, what kind of qualifications they should have, so that when it comes time to agree on somebody, you've narrowed the field to somebody who's appropriate, and it reduces the amount of gamesmanship that one party or the other might attempt. And then finally, I think this is finally, oh no, 2 more. So for choice of law, you have to consider carefully, all patents are domestic, so a Japanese patent should be decided under Japanese law. A US patent should be decided under US law. All countries recognize that patents are territorial. If I have a patent in America, it does not mean I own the invention anywhere else but America. That said, I've been involved in arbitrations where the choice of law, for example, is France, and the patents are in the US, and somebody argues that French patent law should apply to the US patents. In that instance, my opinion, and I think the arbitrators agreed, that was wrong. US patents should never be decided under any law but US law, but the arbitration agreement didn't make that express. So if you think that might be a problem down the road, that's another thing you can put in the arbitration provision. Make it express that any dispute over patents will be decided under the law of the country that issued the patents. And that will just eliminate any disputes, unnecessary disputes over what law applies. Of course, and that also, in most arbitration situations where you've got one party from one country and one party from another country, there's going to be disputes over whose law applies, because everybody wants their own law to apply. So you want to make that express in the contract. And then finally, the seat of the arbitration is important. You want to pick a place that is that's convenient to both parties, or at the very least mutually inconvenient. So if one party is Japanese and the other party is American, you may want to pick the seat of arbitration in Hawaii, or you may want it to be in Hong Kong, or someplace that both parties can agree on, that makes travel easier for everybody. Or it can be remote by Zoom. You can agree to that, and then when there's an actual hearing with witnesses, only then do you go to a particular place. And you have to be very careful also that some countries have very particular rules about what is arbitrable and what isn't. So for example, in China, invalidity arguments are not arbitrable. So you've got to keep those in mind when you pick law and when you pick location. Again, you need to think ahead and look to see whether the law you've chosen is the right law to reach the fair results. So thank you for your time, and I'm going to pass the microphone back to Sakatore Sensei.
Thank you very much, Alex. That's a very thoughtful and informative, and really, helps for our practical strategy, especially for our clients and the users for the litigations and arbitration. So, can I just share the discussion point, just convenience for the audience, and we shall proceed with the our panel discussion and question and answers to but again, we can invite any questions from the audience, inputting their questions into the Q&A box. すいません、ここから英語でアレックスと喋らせていただいて、but as many of you guys are aware of actually Alex can speak Japanese, but for the convenience for the smooth communication, we proceed in English. And actually, Alex and myself have been involved in many such kind of cross-border IP disputes, whether we should step into the litigations or arbitration in by ICC and JCA or something, and we have experienced for the, especially the Alex is very experienced with the Japanese corporations who are naturally hates the US type of a discovery. But for example, like trade secret case, if for example, if the Japanese company is the side who were stolen of the trade secret from the US companies or something, in such case, maybe they may need consider utilization of the broad scope of a discovery or something. So that's kind of a key factors for how we should prepare the litigation or arbitration, although we prefer generally the arbitration for secrecy and efficiency or something. So related to the Alex points on the how to select, how to appoint the arbitrators first, and as Alex mentioned, the if there is any kind of a perfect person who are capable and experienced with the commercial law and the contract law and high technology, IP area, that's perfect, but they might not exist so perfect person. And also, if you implement arbitration clause, like you need to appoint the arbitrators who are experienced with the high technology or US patent law or something. But if you wrongfully put such unclear provision, like, for example, like enough experience or capable of the high technology dispute or something, then that might be trigger another issue, whether such unclear or ambiguous arbitration clause would be, the precisely the correct implementation as the jurisdiction or something. So, Alex, my first question is the have you you have any concern on such kind of a ambiguity or unclearness of the such experience on the patent or technology or something, and how you should deal with the such clear provision on such satisfaction of technology background or something? That's my first question to you.
Yeah, I think I agree with you that I don't think the perfect arbitrator exists. Now, my experience is mostly with entirely with U.S. patents and U.S. patent law. So, some of the arbitrations I've been involved in were, a Japanese company and an American company and U.S. patents, or a German company and a French company, U.S. patents. And the kind of person who can understand the contract issues sufficiently the set of people who understand the contract provisions perfectly, especially if it's under a law that's foreign to the U.S., it tends not to overlap with the kind of people who understand patent law that well. So personally, I've been in situations where I've recommended that the arbitration provision provide for an agreed upon technical consultant to the arbitrators. And that has a number of advantages. One is it's cheaper. It's one person, it's a technical person, and there's many people to choose from who will understand the technology that's subject to the license. So there's lots of people to pick from, so you can have lots of different options for cost. And two, it makes the arbitration proceeding smoother, because that person you can litigate or arbitrate the case before the arbitrators with this technical person sitting there, and that person can go off later and talk to the arbitrators and work with them to help them reach the correct result. That seems to be the smoothest, cheapest, most efficient way of doing things.
Yeah, thank you very much. That's already related to the my discussion point first runs sub-item 2, the high technology dispute resolution, like, for example, recently the joint proposal made by Japan government and the Israel government, how to proceed with the combination of experts and the lawyers or arbitrators, especially for, hybrid type of a common law and the civil law practice or something. But my suggestion to the actually I'm the one with the experts who are kind of involved in such discussion by Anstral, who are now under discussion of what kind of arbitration or what kind of a dispute resolution would be most beneficial or fitting to the such high technology dispute resolution. For example, like 5G or AIs and automatic operation vehicles type of technology, which can survive only very short time in the market. If you fight like for more than 6 months, that's too late. Something. In such case, as you suggested, if you have a one experienced arbitrator and with the expert sitting, that's very helpful. And also, my suggestion is such expert may have a power on some evaluation on the technology side or something. So in such case, stepping into some combination of arbitration and mediation, that some sort of not only the facilitating mediation, but more sort of evaluative mediation could be some helpful. That's my sort of a suggestion to the Japanese government and the Israeli government. But how do you think on such, what kind of a dispute resolution system of operation would be fitting to such very high technology area?
Yeah, I agree with everything you've said. I mean, again, yeah, especially very high technology cases. One of the arbitrations I worked on had to do with the genetic modification of plants, and no arbitrator understands that. No arbitrator understands the technology unless it's explained very carefully, very slowly. And in that instance, the parties had not agreed to have somebody with a technical background who was a neutral to assist to assist the arbitrators. And when the arbitrators came down with the final decision, as bright as they were, and they were very, very smart arbitrators, they just didn't understand the science. And so this idea of bringing in an expert who's a neutral, who can just sit with the arbitrators in an unbiased way, because in an arbitration, obviously, one side says their version, the other side says their version, and maybe the two don't meet as to describing the technology. But having somebody in the center who's not biased, who can teach and who can understand, that strikes me as a good way to keep things efficient.
Right. If you can implement and they provide such sort of provisions into the contract, that's best. Yeah. But even without that, then maybe under discussion with the adverse party, maybe who might have a common interest with you for first resolution and saving the cost and timing, maybe you can agree, okay, let's have one expert with the arbitrator. So that's a quite good idea, I agree. Okay, thank you. And then one question from the audience is this is my sort of a favorite question. It's online type of operation, because the question is if the difficulty of moving out in the country, and if it's difficult to site visit, it's quite tough for the to proceed with the arbitration or mediation or even litigation in person. Then how you can proceed with the arbitration. So maybe I should follow up with you, but Alex, you have any idea or how is the situation in the US and the cross-border litigation and arbitration?
Yeah, So one of the nice things about arbitration, as you mentioned, is that the parties can get together and agree on something because it makes sense, because it's more efficient. And so they can agree to do everything by Zoom or do everything in a socially distanced way where you don't have to leave your own country. You can't do that in litigation. Litigation, the court decides. And so in US litigation, we have 50 states with 50 sets of different rules for COVID. We've got the federal courts. Every federal court has different rules. Some courts, like in Texas, have had live jury trials already, and nobody likes it. The jurors don't like it. They don't like to be put in a room indoors for a month or 2 weeks. The litigants tend not to like it, but they're forced to do it because if that's what the courts want, that's what you have to do. But with arbitration, there's so many more options because you can just agree to whatever makes sense.
Yeah, I agree, completely agree. And also in Japan, the court, the litigations is very, delayed for the online operation. And but for the cross-border arbitration, the mediation, we can do that. And actually, I'm now at my home, at my basement. Actually, I did the cross-border and online mediation from my home with the Singapore institutions and Japanese Kyoto Mediation Center. And such first joint protocol case I was conducted from my home. And then the Singapore side, they are from the Singapore law firm and the Singapore institutions, and other foreign companies are zooming in for the operation from their country. And so all those parties can proceed by such online and the web hearing system, not only the mediation, but also for the arbitration. And although there are some careful the points which you have to consider, like for how to avoid coaching, how to avoid and how to keep your efficient objection timing. And even the parties raise a hand and objections, but if arbitrators cannot make attention onto that, and then if that's proceeding, then could be triggering in the worst scenario some challenging on the arbitration award or something. So actually, I'm the chair of the web hearing committee of the JIDRC, and not only for the such technology equipment side, but also for due process carefulness for the how to avoid coaching, and especially for this type of IP area and technologies, comment and the witness could be the key for your decision. Then if the witness is kind of coached by by the one of the mic headphones or display of the computer or something, that could be triggering another issue. So for carefully making a countermeasure on it, we are proceeding with the online arbitration. That's the current status. That's very good question. And even after the post-corona, post-COVID-19, I think this kind of trends on the utilizing the online would be quite continuing, because another convenience for such online web hearing or online mediation is the availability issue can be resolved, because maybe as like you famous and popular litigator or arbitrator, very busy, it's quite tough to make a scheduling for the available dates or timing for the arbitration mediation. But if you can do by online, then that's quite convenient for making available for the those very super busy practitioners. Although you have to be careful for the time zone difference issue. I mean, even if you can connect for the witness examination, but if the witness is examined at their midnight from 2 a.m. or 3 a.m. or something, that could be another some issue for challenge or something. How do you think? I mean, so it's already stepping into the another my points for the how about the post COVID-19 for online utilization, especially for the IP area. How do you predict and how do you think on such post COVID-19 practice, Alex?
Yeah, so first I want to go back and say you made a really great point about delay, which is in the U.S. courts, almost all of them have a backlog of trials. So one judge can only have 15, 20 trials a year. They take so much time, and for almost 2 years there were no trials. So you've got this enormous backlog of cases that want to go to trial, and if they don't settle, you just wait and wait and wait. And so this might be a really great time now for arbitration, because if you don't want to be stuck in the back of a line with 10 other, with years of waiting for a time with the judge, then arbitration might be the way to go. But to your question, I think, creative parties can always overcome the problems of time differences, problems of language. I find that they never really are that restrictive. I know people in litigation can be unnecessarily difficult, but it's not that hard. I mean, we're on the opposite ends of the world right now, and it's 10 p.m. my time, and that's not a problem. And so for arbitration, somebody can wake up a little early, someone can go to bed a little late, and it's so much better than traveling to another country that it's sort of a minor inconvenience.
Yeah, thank you. Yeah, actually, I was asked by the Israel government and the Czech government to speak from the 2 a.m. at the Japan time. It's not so kind of a human being time zone. Maybe that's okay for the presentation, but not for suitable for the with this examination something. So another question is from the audience is to Alex is the for proceeding of the arbitration. So you showed some neutral technical consultant appointment, and such option would be good. And first question is how from where you can find such consultant, from which resource? That's first question. And then if the consultant is providing some technical explanation to the arbitrator, such substance or the contents of such correspondence, question and answers from the consultant can be disclosed to the parties, and to what extent such disclosure could be made to the parties regarding the consultant questions substance something. So that's a question from the audience.
Yeah, I mean the best way to do it is, as with everything in arbitration, is by agreement prior to at the time of signing the contract. So if it's a Japanese company and an American company, and there's a potential for arbitration over a patent issue, you can say, okay, here's if there's going to be a technical consultant, and here are the requirements. One, that they have to understand the following 5G technology, and at the very least, have worked in the industry for 5-10 years and have a degree in the following area. This person cannot be Japanese and they cannot be American, and that way nobody will complain that the other side has an advantage, and then the pool of available people is enormous for most technologies, and so you just lay down the requirements, and then, as with everything in arbitration, you just work out an agreement as to the person.
Right. And if in the case of my being the arbitrator, should try to get all things such process to obtain the agreement from the parties. For example, like how to disclose, to what extent disclosure of such consultation substance between the arbitrator and consultant or something. If the parties can be agree upon such process, then let's go ahead. So that's the kind of area of the parties' agreement would be the key. So a little bit tough question. If parties cannot agree upon such, detailed operation, then arbitrator have to determine or make an order or something. To the extent that may not be violating any due process or a rule or something. How do you deal with it, the Alex?
I mean, it's the same difficulty with picking arbitrators, but you could have a procedure. For example, each side gets to propose 4 or 5. You could have a ranking and a voting system, and see who gets the most votes. Proportional voting. You vote first choice, second choice, third choice. You could say the arbitrator picks from 5 people or from 10 people. There's multiple ways to do it so that neither party thinks it's unfair. It may not be there to their liking. Nothing's ever perfect, but you can have one of these mechanisms to ultimately let the arbitrator pick in a way that's kind of the choices are narrowed by the parties.
Right. Then within the scope of the arbitrators or arbitration tribunals authority, maybe they can decide, and they should decide how to proceed with the such, to what extent disclose of their consultation between the arbitrators and consultants, something like that. So that's the how to proceed with the arbitrations. Right. Okay.
Did Douglas have a question? I saw something on my screen that said he had a question.
Oh, Doug, you have any question?
Do you have a quick?
Sure.
Do you have time for just a quick question?
Yeah.
Sure.
No
so Alex and Yoshi, thank you for this very illuminating discussion and presentation. So I had one question for Alex. You mentioned that WIPO rules have contained the appropriate provisions for addressing IP issues adequately. And some of our participants may not be familiar with the WIPO rules generally and may be more inclined to choose ICC or JCAA commercial arbitration rules. In what types of agreements or circumstances would you recommend specifically using WIPO as an arbitral institution and their rules, if you have any sort of guidelines or suggestions, comments?
I tend to prefer ICC.
Is that right?
But WIPO is more, if you really think that patent issues will predominate, which is unlikely because it's usually you're in the context of a contract and usually the contract issues predominate. But if you think the patent issues will predominate, then maybe give a look to the WIPO rules, especially if you think there's going to be a need for elevated levels of discovery like site visits or experiments to determine what is in the product itself. But that tends to be rare. I haven't found myself in a place where I've recommended WIPO yet, but maybe one day.
Thank you. Very helpful.
Great. Thank you very much. Okay, so maybe it's time up. Thank you very much, Doug and Alex. And also, I really appreciate the Kanki-san and the 法務省。ちょっと日本語で最後、締めますね。ありがとうございました。非常に勉強になりましたし、多分最後のICC の使い勝手がいいよっていう話は、多分ICC の方にまたこのビデオ録画をプロモートしてもらえればな、みたいにちょっと思ったりしてます。今日は非常に知的財産に、特化した、そのディスピュートレゾリューション、アービトレーション、メディエーション、の使い方ということで、研修動画のアップを記念してということですが、知財をもっと超えてですね、ジェネラルにも非常に有意義な、ディスカッションができました。重ねて、アレックス・チャチキス、ドグラス・フリーマンから主催してくださった、関係さん、法務省の方々、皆さんに、感謝申し上げますし、有意義な質問いただいたオーディエンスの方も、ありがとうございます。それから、アシスト、リンクのですね、送付とか、あと手伝ってくれた、秘書の矢板さんにも、感謝申し上げます。ということで、今日の セッションはこれで終了いたしますが、途中質問いただきましたが、アレックスの、アレックス・チャチキスのプレゼンテーションマテリアル、それから私が作りましたものも、これもリンクを貼ってダウンロードできるような形で配布を予定していますので、よろしければご参考いただいて、それから元本丸というか、法務省さんのホームページには、研修動画、英語で実際行った模擬国際仲裁、調停ですけども、私の方で日本語でも解説しておりますので、ぜひご覧いただければと思います。今日はどうもありがとうございました。Thank you very much. Again, Alex and Doug, thank you very much.
Thank you.
それでは終了いたします。ありがとうございました。
Thank you, everyone.
Thank you.
ありがとうございました。